I wanted to raise the issue regarding whether or not some additional statements should be a part of any bills that would create retroactive law changes. Specifically, I'm referring to a few times per year in the California legislature, you might see language in a bill that says, quote, this act does not constitute a change in, but is declaratory of existing law, unquote. Now, what's the purpose of this language, and should these types of declaratory statements include other legislative statements such as findings and declarations or maybe even legislative intent? Uh, I raise this because in a recently introduced bill during the 2024 legislative session, this language was contained at the end of the bill. It said, the addition of section 7923.611 to the government code made by this act does not constitute a change in, but is declaratory of existing law. And I thought in reading it, shouldn't this bill contain some additional statements in order to, I guess, properly set the stage for this type of language? From my perspective, it's an emphatic yes to that question. Why? Because I think the legislature should include more than just a simple declaratory statement. And I've said this in other areas as well. um, you know, just making the claim or the statement, this act is declaratory of existing law, I think the legislature should set the basis, set the stage that here's the need for this law change. They're effectively making it retroactive because if it's declaratory of existing law, then these changes contained in this bill go back to when that original statute was adopted by the legislature and governor. And the best way of doing that is to include, one or more legislative findings and declarations. And then following those findings, they could add language such as legislative intent statements that basically make clear what the purpose is of the new changes to that original statute. Findings and declarations can provide some factual information or a value statement about the needed retroactive change in the bill. And they can describe the problem that the legislature is trying to address and why the first statute needed clarifying language added to it to begin with. Then the legislative intent statement could specify the legislature's intended result based upon these law changes. And in my mind, including these types of statements would be helpful to address any potential legal challenge to the legislation because courts will consider these official statements of the legislature. And so then in these additional statements, the legislature could actually make clear why the bill is quote unquote declaratory of existing law. We also know that legislative intent statements are important for providing an explanation or a rationale, not only to the judicial branch, but the general public, perhaps the regulated community, even the executive branch that's applying or interpreting or adopting a regulation based upon that statute. And I think, as people can appreciate, in most instances, legislation, of course, applies prospectively, meaning after the law has been enacted and takes effect, that's when the law takes effect. And the ultimate determination, though, to whether an enacted bill is intended to apply retroactively is made by a court of law in this state. The legislature, by saying it's declaratory of existing law, is in essence short circuiting that process and trying to tell the judicial branch, yeah, your job is to interpret the statutes, but we're telling you that this is declaratory of existing law. Now, if you look at some of the California appellate court decisions that have been published, many, not many, a number of them talk about this. One I found said, quote, a statute's retroactivity is, in the first instance, a policy determination for the legislature, and one to which courts defer absent some constitutional objection to retroactivity. So the basic rule, as the courts have said in California, is that a statute may be applied retroactively only if it contains express language of retroactivity or if other sources provide a clear and unavoidable implication that the legislature intended retroactive application. Moreover, the California Supreme Court has made the statement that where a statute provides that it clarifies or declares existing law, that it is obvious that such a provision is indicative of a legislative intent that the amendment apply to all existing causes of action from the date of its enactment. In accordance with the general rules of statutory construction, we must give effect to this intention unless there's some constitutional objection thereto. So California courts look to the text of the bill and legislative materials to determine whether the later enacted bill made a change in the law or whether the later enacted bill clarified existing law. And if the bill represents a clarification of existing law, then the bill is determined to apply to all instances, both retroactively and prospectively. On the other hand, if a bill enacts a change in the law, then a court will look to determine whether the legislature intended for the law change to be applied retroactively. And in this regard, California courts basically asked, did the legislature make a clear intent to apply the amendment retroactively? And many of our state appellate courts have explained, such as this one, a subsequent expression of the legislature as to the intent of the prior statute, although not binding on the court, may properly be used in determining the effect of a prior act. So, yes, generally they'll give effect to it, but why even have the court go into this, whether it clarifies or makes a change in the law? Let's just put it all out there and set the content, the context, and explain that if even if the bill says this bill doesn't constitute a change in, but is declaratory of existing law, I think they ought to include some statements of intent and findings and declarations in addition to the standard form language. So this will better ensure that any sort of clarification of existing law will be held up by the courts in this state, ideally, which is ultimately the goal.